You're listening to The Rule of Law, the educational podcast sponsored by Allrise, where we focus on the intersection of law, technology, and storytelling. And now, here's your host, Lauren Round.
Welcome to Rule of Law. In today's episode, we sit down with Kelly Twigger, CEO of Minerva 26 and principal at ESI Attorneys. We discuss why all attorneys need to upskill in the eDiscovery space, the most challenging parts of working with electronically stored information, and how to find a reputable partner to assist in handling the technical parts of discovery. Kelly, welcome to the podcast. Where are you recording from?
Hi, Lauren. Thanks so much for having me today. I am in Boulder, Colorado.
Boulder, welcome. Well, we have a full docket today. We're going to talk about all the awesome work that you're doing in the ESI and eDiscovery space, talk about some malpractice risk there and some best practices. But before we get to all of that, we always start the show with an icebreaker. So your question is, if you ever moved outside of the US, where would you move and why?
My off-the-cuff answer would probably be England. My husband's from England. We have family and a lot of friends there, and I just love it there. So we are there every year or two. But I also would really love to be able to explore living like in the Italian countryside. That sounds very peaceful.
I know that's a great, and there's no boundaries on that question. So I've got Tuscany or
Yes.
the Greek Isles or something like that. So yeah, well, we can dream.
Yes.
Before we get into some of the substance, if you wouldn't mind just sort of introducing yourself to the audience, tell us a little bit about your background and your journey to where you are today.
Sure, absolutely. I have been a practicing attorney for 28 years. I went to law school at Marquette University, and it was great education because I had the opportunity both to clerk for a judge, work in-house, and as well as be a prosecutor for the state for a year. And so by the time I left law school, I had a lot of practical experience to choose from. I ended up working at Quarles in the commercial litigation group and was a partner there for a number of years. Left and started ESI Attorneys. Once in the early 2000s is when I really fell into electronic discovery. That was when, right before the rule changes happened to the Federal Rules of Civil Procedure, which identified electronically stored information as a category of information to be discovered under the federal rules, and state courts seemed to follow. And so all of that, learning all of that, creating all of that, helping our lawyers at the law firm understand all of that really became my job at the firm. And then about 4 or 5 years later, I left the firm to really take eDiscovery out on my own to be able to work for clients. And so formed our law firm, which is called ESI Attorneys. And at ESI Attorneys, we do exclusively information governance and eDiscovery consulting and working as discovery counsel. I do expert engagements as well. And I'm open to doing special master work. So really just spending all of my time in electronic discovery. Along the way, as all of the rule changes happened and everything needed to be tracked in terms of jurisdictions and the case law was developing, we started cracking it all. And so then we ended up building a piece of software, which was called eDiscovery Assistant until earlier this year. And now it's called Minerva 26. And that is really a discovery strategy platform where our goal is to help lawyers who have a lot of difficulty staying up to speed on what's happening in electronic discovery, really have the tools at their fingertips to get answers to questions. So Minerva curates all the workflows and the case law and the rules and education on eDiscovery to allow you to get up to speed quickly and be able to address that. It's so hard because it's a constantly evolving landscape. As technology changes, that means our interpretation from a rules and a case law perspective changes. And we see so many issues that crop up each year with regard to technological changes that impact our obligations as lawyers and our responsibilities to clients. So I do both Minerva and the law firm. And then this semester I'm teaching at the University of Colorado Law School, which is it's a 2-credit class. And it's a lot of fun to be able to talk to the students and help them just get a baseline for coming into the practice of law and starting to see electronically stored information as evidence. So it's a change. It's a change for everyone to be thinking about.
For sure. Yeah, and I want to get into some specifics about the world of ESI and eDiscovery, but one last question about you specifically, because as you're talking about you had the law firm, then you founded the company, took on teaching, and most people that we talk to, they sort of transition from one thing to the next thing. Either they leave the practice of law, or they might have been in the private sector, or working for a company, and then decide to go back to law school. But it seems like you just, taken more things on as you go. So, I mean, really, how do you do it all? And also, have you ever thought about leaving the law practice and kind of transitioning to the company side of it full time? Or do you think you'll just keep doing everything?
The last couple of years, I've spent more time just on the software, building out the software elements in the company. And there's some big changes that are coming to that just because of the advent of AI, and that allows us to do a lot more in terms of creating natural language searches for folks to be able to get up to speed. No, I really like doing all of them, to be honest. And the practice feeds the software, right? Because the more we do in practice, the more I'm able to create a platform that allows other lawyers to be able to leverage what I know and have learned. And the teaching is making sure that the next generation of lawyers is understanding ESI and have just the baseline knowledge to get into it, to start doing it. Because the only way that you really learn how to do electronic discovery effectively is to do it, and to make mistakes, and to do it better the next time, and to listen and learn and read and figure out how to do it. And as lawyers, it's really hard to constantly learn new things while you're practicing, because we have such a nonstop work environment. And so, they all kind of naturally flow together. It's not like I have to stop and figure out how to teach a course, because mostly what I do all day, every day is basically teach it, whether it's teaching it to my clients or to outside counsel or negotiating or things like that. So there's some organization around it, but we have an amazing network of legal educators that Bill Hamilton from the University of Florida Law School brought together. And so we trade ideas, and we trade syllabuses, and syllabi, I guess I should say, and we share ideas. How are you doing this? What's the most constructive way to teach students how to do a custodian interview when you've got a room full of students, right? So there's a lot of camaraderie from folks in the profession, and it's a very tight-knit community, the eDiscovery world. So they all kind of flow off each other. I love all of them, so I will keep doing them. I don't teach every year. This year, I've gotten a little bit more flow, and I'm very lucky to have some terrific industry experts who come to the class and teach as well. So I feel like it's important to give back, and that's one of the ways in which I try to give back.
That's awesome. Yeah, no hate to full-time professors at all, but my favorite classes in law school were always the adjunct professors who would leave their day job and come teach to class, just because it was so practical. And maybe we didn't learn a lot about what was going to be on the bar, but we learned a lot about how to actually do day to day once we left law school. So I'm a big fan of those courses.
Yeah, and that's exactly what I try to do. Is I even tell my students, look, I'm not here to kill your grade point average. I'm here to make sure that you know and understand and appreciate the importance of electronic information in terms of discovery. And I'm just trying to, we only have 14 classes and 2 hours at that per class. So trying to really give them a baseline in all the key concepts in electronic discovery for them to be able to leverage going forward. And I just have enough knowledge. And that's all you can really get in law school, is enough knowledge to get you started. And then you've got to get out there and practice and see how you can apply the theoretical concepts to reality. But we try to do a lot of practical discussion, including little things, stories that I have when I bring guest speakers in. They give their views and perspectives. And the law and practicing law I call it the 98% rule that I use. And I hope you won't be offended on the podcast, but I view the law or the practice of law as being 98% bullshit and 2% law. So it's literally 2% about what the black letter law is in a case, and it's 98% about who your judge is, where your case is located, what your facts are, who the parties are that are involved in your facts, what the public perception is of the parties who are involved. There's so many things, who the lawyers are, how hostile the working relationship is between the lawyers, or how adversarial, I guess I should say. And so all of those things make up the 98%. And when you're evaluating a case or a discovery strategy, you have to take all those things into account. I view my role in terms of teaching is to help the students understand that you can learn all the black letter law you want to, but when you get out, it's about life. And life is everything coming at you at once and you having to make a decision in the moment based on what you know. So yeah, it is very practical.
That's so true. And I mean, that's one of the reasons why I think AI is and will continue to impact the legal industry, but I don't think we should underestimate the human part of it, because a lot of it is when you have a legal issue, you want someone to make you feel better. You want someone in your corner to be able to talk to and get advice from. And it's a feeling more than if someone just impresses you with knowing the black letter law. So I don't want to really get down that rabbit hole because that could be a whole podcast.
Yeah, AI is a whole like 4-hour podcast in and of itself. Yeah.
Exactly.
Yeah.
Well, moving back to kind of the specifics around your expertise, the ESI and eDiscovery space. And for listeners, I want to say at the outset, even if you're not a litigator, I mean, no matter what type of lawyer you are, you have ESI, electronically stored information, and you never know when you may need to produce it or recover it. So this conversation is super relevant to everyone. But with that said, you kind of alluded to this earlier. ESI and eDiscovery really started in earnest in the 2000s. We've had email since the 1990s, actually way before that, but in the mainstream since the 1990s. Texting became popular in the 2000s. Everything is online now. So you would think that ESI and eDiscovery would sort of be, for lack of a better phrase, figured out by now. But can you talk to us about how that's not the case and why there's still so much uncertainty and unknown in this space?
Yeah, well, it certainly is not figured out. I would say this. And I think there's two ways to think about it. One is not figured out because lawyers they have their process and they've been following their process. And when data became the evidence instead of paper, when we switched from paper to electronic information, most lawyers just sort of took that in stride and continued in their same process, handling information in an electronic format. They just get a PDF, right? So they just get a PDF, they'd print it out, they'd handle it the same way they were handling paper. And so there's that piece. So if there's really two trends here as to why this isn't more widely adopted, it's one, because lawyers have just continued to handle ESI as if it's still paper. And so that lack of adopting ESI and as evidence and a new way to think strategically about discovery is one problem. That's one reason why eDiscovery hasn't been widely adopted. The second reason is because even those of us who spend our time in eDiscovery 24/7, the technology literally changes every day. And so there's all these folks over here who haven't changed their process. They look at the need to be on top of things and they go, I think we forget that litigators already have two jobs, right? They are supposed to be experts in the subject matter of whatever the litigation is, right? It could be antitrust, it could be real estate, it could be contract, it could be mergers and acquisitions, it could be any number of things, construction, right? So you've got to know all the ins and outs of the practice area that you're in. Then you've also got to be a litigation strategist. You've got to be able to know and understand and use the rules to your client's advantage and in a meaningful way to meet your obligations with the court, but also give your client whatever advantage they can get and help them understand the facts as quickly as possible. Now we've added a third job, and that third job is becoming an eDiscovery lawyer. And so instead of them doing the third job, a lot of folks have elected to have someone else be the eDiscovery lawyer, or they just have folks downstream handle data. So eDiscovery has opened up a whole new world of litigation support services that didn't really exist before. We had litigation support, but it was a much lower thing. It was getting ready for trial. It was preparing exhibits. We had paralegals who helped us get ready for the day-to-day depositions, hearings, things like that. And then we had lit support who helped us more in the trial process. Now, because of the influx of data, because of eDiscovery, there's this desire to push everything with the data down to the litigation support folks. And in doing that, we lose out on so many decisions that need to be made in discovery strategy out of the gate. So if I'm saying to my lit support folks, and there's always the problem that you be at a law firm that doesn't have a lit support group. So you might outsource it, or you might have some hybrid of that. You might have a lit support group, but you also outsource, and that lit support group manages the outsourcing. There are so many decisions to be made all the time in every aspect of identifying, collecting, reviewing, filtering data, that not having the lawyers engaged there means that they're missing out on all that decision making. And when you miss out on all of those decisions, I called it the eDiscovery disconnect, right? Where the litigators have pushed all the data related decisions down to non-attorneys or people who are not involved in the case itself. They're missing all of these decisions. And that disconnect really costs the client more money. It pushes decision-making or potential settlement or knowing the facts down the road, which costs more and more money. There's also a lot of decisions that from a business development and a client relationship perspective, we would make in discovery that we can't make if we're not involved in the process. So to circle back to your question, it's really become difficult because either one, we're still handling discovery like it's still paper, which is a complete and total mistake in my judgment, because there is such an opportunity with ESI to do things better, faster, more efficiently. And then we've got the second problem, which is that it's a third job for lawyers and they don't know how to do it. And it's very difficult to stay on top of. I just did a webinar recently on hyperlinks, and that's the latest and most popular issue. And I know we want to get to that, but the point is that Google and Microsoft, which are the two biggest email service providers that involve hyperlinked files, they're changing every day what they're doing. And so how do you know? And so we try to provide a lot of education on those realms for people to be able to sign on to and at least get the latest of what's happening. And that's part of what Minerva is designed to do as well, is to have a place where you can go and get up to speed on these issues when you need to, at whatever time you need to.
So all that being said, is there sort of a sweet spot for attorneys where, okay, we understand that you can't take on a full-time third job of handling ESI and eDiscovery properly, but we still want you to be involved in decisions because, as you described, if you're not involved in any of it and you outsource it totally, that can cause its own world of problems. Is there a sweet spot where attorneys can still outsource or delegate, but still be in the decision-making process to avoid some of the issues?
Absolutely. I outsource. That you absolutely can outsource. You just have to be in the game, right? You can't just outsource and leave it to the party you outsource to, whether that's another attorney or otherwise. And so the sweet spot is you need to sit down and identify what are the issues for the types of matters that you handle, right? There's very different eDiscovery issues in a family law matter than there is in a large commercial construction matter, or even an antitrust matter or some sort of regulated industry. So every case has ESI, every single one. Personal injury cases, whether it's a car accident or whatever, if someone's texting at the time that causes an accident, you can literally, using GPS data, pinpoint whether someone was texting at that exact moment, what the timing was of the light that they were sitting at, when the black box in the car will give you information. You can piece all of that together to tell a story. And so every type of law that has evidence, it's electronic now, and you have the ability to tell this story. So the sweet spot is knowing what the story is, what kind of story you need to tell for your clients, and what kinds of electronic information exists to be able to tell that story. I think of it as, if you like to do puzzles, you get a box of puzzle pieces and you dump it out on the table and you start putting it together. You might start by putting the edges together. In eDiscovery, you don't get a box of puzzle pieces. You have to go find them. And you have to know where to look and what to think about. It's how can you tell a story with electronic information? You need to start thinking about every single day as you're creating, receiving, and sending electronic information, whether it's email, text messages. You're sending a ping to a cell tower by having your phone in your car when you're driving. You're driving, so the black box in your car is recording information. You're using navigation. You're using Google Maps. Whatever you're doing, just start thinking of it as keeping track of electronic information, and how could you use that electronic information to tell a story. And for lawyers, if you just start thinking about ESI as evidence and how you create, store, send, and receive it, you can learn to figure out how to tell that story. You don't have to be the person who's the expert at getting the GPS data, collecting the mobile device. You can outsource all of that. But when you know what it is that you want, you can call up the service provider or the technology company and say, I need you to image this cell phone for me, or I need to get this information off of a cell phone. Here's the story I'm trying to tell. And then they will help you tell that story, and they will come back to you. If you just say, I want you to image this cell phone because I need to preserve it, then they're going to image it and they're going to hold it for you, but they're not going to help you tell your story. And they may not necessarily take the exact steps that you might need to tell your story later. So you got to think ahead now. The thing with ESI is you need to be thinking much more in advance about what is the story you want to tell, what is the information you're going to use to tell it, and how can you collect and maintain that information in a way that allows you to tell that story. A lot of what we rely on now are the rules, which give us the framework we have to operate within, and the case law, which tells us a lot about how courts are seeing these issues, how they're ruling on them, what they're requiring parties to do. If folks are interested, one of the ways in which I try to educate people about those things is through our podcast. It used to be called Case of the Week, and now it's called the Meet and Confer podcast. And we spend a lot of time talking about case law, about the rules, about the challenges of tying the language of the rules to electronically stored information, because the rules were crafted with language that never envisioned ESI, right? So we get really complicated issues like Rule 34, the Rules of Civil Procedure, requires that a party provide information that's responsive to requests that is within its possession, custody, or control. Well, if you're talking about whether or not an employer has possession, custody, or control over an employee's cell phone that they may have texted on that might be responsive information for the case, how do you determine whether or not an employer has possession, custody, or control? So those are the kinds of complexities that come up in discovery all the time. And that's why it's not solved. I mean, it's constantly evolving. So it's a hard thing to stay in touch with, but it's your sweet spot is what you need to know for your cases, and then identifying some sources of being able to stay up on this information.
Sure. And I think from the client perspective too, I mean, if I contact a personal injury attorney, a divorce lawyer, whatever it may be, a business acquisition, whatever, I think from the client perspective, most people out there just assume that the attorney is going to piece all that together and do everything they need to do to discover all the ESI that's relevant to them. I think most people would be disappointed if they found out that the attorney didn't do their due diligence in discovering everything that they needed to help them. I know there's some malpractice components to this as well, but I think that seems like a reasonable client expectation.
It is a reasonable client expectation. Yes.
Deploying new software technology can disrupt familiar workflows and processes, and it often comes with a steep learning curve for the employees in your law firm. We get it, but it doesn't have to be that way. All Rise is a comprehensive law practice management system deeply integrated with the Microsoft tools and technology you're already familiar with. So no steep learning curve is required. And because All Rise is a modular software platform, you can deploy only the specific capabilities you need when you need them. Your choice. If you want to streamline internal operations, boost staff productivity, and deliver superior client service, then take a close look at the AI-powered All Rise platform. It's time to experience software innovation that enables practice excellence. Learn more at allrise.ai.
I want to move on to a topic that you mentioned earlier, and that is hyperlinked files. Because as you said, it's one thing if you are in Discovery, you need to locate an attachment and it's a PDF and there's only one version. That's like more straightforward. But it's a whole other thing when you have 150 emails and half of them have a hyperlink to multiple versions of a file. We don't know which version is which, can really easily become a mess. And again, I know we could probably have a whole conversation on this one topic, but at a high level, walk us through what's new in this space and what the most difficult pain points are?
So hyperlinked files present a number of challenges. And if folks are interested, if you want to sign up for our newsletter, then you can get information on the next, even the existing, but also the next webinar that we do on this, because I just did one recently. Hyperlink files are a problem because instead of physically attaching a document to a correspondence, whether it's email or otherwise, you're now providing just a link to that document. And when you go to collect, you go to preserve data for eDiscovery purposes. Whenever a party reasonably anticipates or has notice of litigation, they have a duty to preserve any electronic evidence that might be relevant to the matter. And so when you have that duty to preserve, and let's say you have email, you have Teams chats, you have text messages, and all of those sources, WhatsApp, even Signal, all of those sources, people exchanged links to documents in them. Then the question becomes, are you required to provide the document that is at that link? Most courts have said yes, if it's relevant, right? If the document is relevant, if the content that the link is sent in is relevant and responsive. When you look at those links, there are multiple problems. One, which version of the document are you going to collect? When we deal with electronic information, every time someone touches that document, even opens it up, it creates a new version within the system. If I sent a text message to you on September 30th at 9:35 a.m., and you opened it at 11 a.m., then those are two different versions of the document. So when I go to collect the text message that I sent you at 9:35 a.m., I may want the version that I sent right then and there, but technologically speaking, the system that contains that information may not be able to provide that version, the contemporaneous version, which is the version sent at the time the message was sent. That includes it. So versioning is a big issue. And oftentimes what we do is we agree that we'll provide the version that exists at the time it was collected, right? So say that's 2 years later. And if you say, I need that version from 9:35 because there were changes made, then maybe we can go back and get it. But it's all about the technological limitations of the tool that's storing the information. So versioning is one issue. Another issue is, how do you preserve data? So usually, and we're moving away from this, but in eDiscovery, we typically identify specific custodians, specific people who are responsible for creating information. And we would preserve data by keeping information for that particular custodian. But what if that custodian, say I'm a custodian, but you're not? And let's make it the other way. Let's say you're a custodian and I'm not. I created the document, and in the 2 years since before the collection, but since I sent the text message to you with the link, I've taken you off the permissions for that document, or I've deleted the document entirely. Then the question becomes, do you have possession, custody, or control of the document such that it can be provided? No, you don't, because you don't have access to it anymore. And then what if it's been deleted? What if it's gone? What if it no longer exists? So the rules have always been that we can only provide the information that exists at the time that our duty to preserve arose. So we see a lot of motion practice about failure to preserve data, failure to produce data because it should have been preserved. It's so all over the map. So you've got versioning. You've got, how do you preserve actual data for different custodians? And then there's the complexity of, do the tools that you actually have allow you to collect that information? It's just crazy what we're into now. So hyperlink files are a cluster. It's really important that you're paying attention to them. There's a lot of really great case law out there now on hyperlink files. It's pretty much universally acknowledged that they are attachments as we considered them, or that they should be provided. They're not treated the same as physical attachments. The other problem with hyperlink files is that there's no metadata to relate the document that you filed. Let's say instead of it being a text message that I sent to you, it was an email on Google Mail, and I had Google Mail and you have Google Mail. If I send you the link, you no longer have access to the document, but you could come to me because I was an employee at the same company and get access to that document. Then you could provide that document. But the way that data works with physical attachments is there's metadata that physically attaches that document to the actual email. With hyperlink files, there's no such metadata. I may go and collect all of my documents from Google Drive and all of my messages and give them to you, and you have both, but you don't know which document goes with which email. And so metadata is a huge problem. So there are tremendous problems with hyperlink files. A lot of people are going, well, wait for the companies, the Microsoft, the Google to fix it. What's the incentive of those companies to solve eDiscovery for us? There's not really any. There's no ROI for them. So it's a huge challenge. Hyperlink files is a big issue. A lot of the ways that people have addressed it right now, just to give the listeners some solutions, is to sample. And that is to say to the requesting. So let's say you requested documents from me. I gave you documents. And we agreed that you would review the documents that have links in them, and you would tell me which ones you wanted the documents for. Now, when you're talking about producing thousands, hundreds of thousands of documents, that could be a lot. Parties have set up sampling protocols where they'll say, we'll give you 20 requests a week, and you get 2 weeks to respond to those 20 requests, because it's very manual going to get these documents from these links. It's not an automated process yet. And that's what makes it so difficult. The physical attachments have an automated process to collect them together, keep them grouped, metadata, et cetera, et cetera. We do not have that with hyperlink files yet. So it's a challenge.
Yeah, I think this is one of the areas where normally we think about technology making our jobs easier. And if you think about discovery pre-internet or even email, just sifting through all the physical documents and having floors of associates highlighting things, it certainly seems like technology has made things a lot better. But then I think about hyperlinked files and how big of a step backwards that is, as opposed to just attaching documents, because you can't even see what documents are attached to an email. That seems like such a big challenge.
It is a big challenge. And using the sampling process that I mentioned puts a burden on the requesting party to then identify which documents they want, which hasn't existed previously. But the reality is that the courts can only order what technology allows parties to do. But I will say this, it is really important if you're going to the court to argue these things that you have somebody who knows what they're talking about, because courts are very susceptible to being told the wrong things. These judges don't have eDiscovery, even for federal magistrate judges, a very small part of what they do. And it's not their job to be up to speed on these things. They try to be educated as much as they can, and some judges are great at it. It's your job to explain it to them. And so you need to make sure that it gets explained correctly, because if the other side explains it incorrectly and the judge rules in their favor, you will be stuck with that ruling. Most discovery rulings, there's an appeals process where you can, in the federal level, you can go from the magistrate to the district court. But generally, it's a high threshold to meet to be able to show that the magistrate judge's ruling was incorrect. It's not very appealable. It's really hard. You have to get it right the first time. And in order to get it right the first time, you have to start really early in the case, sitting down, thinking about what the eDiscovery issues are.
So in this area, this is very overwhelming for attorneys who aren't steeped in this space. So I think it's easy for attorneys to sort of fall into the trap of, I'm going to do my best, but I don't have the time to develop the expertise on this. What is your best advice for kind of how they can go about educating themselves or finding a reputable person to outsource so that they are, mitigating malpractice risk and just ensuring that they know sort of the basics to deliver the best results for their clients?
Yeah, so the best way to really learn the effectiveness of eDiscovery is to start doing it. So if you're currently just agreeing to accept non-searchable PDFs or even just a searchable PDF, I would encourage you instead to get a format of information that allows you to filter by metadata. When you get a collection of documents that's just in PDFs, there's no organization to them. And if you don't have metadata that you can load into a database that allows you to filter them, you can't even filter them by date. You can't even filter them by date to be able to find out chronologically what happened. There's so much value in leveraging metadata with ESI and I mentioned it a little earlier, the opportunity of ESI, it really gets you in a place where you can do so much more. Think of it almost like an AI. We feel like AI now allows us to do more with less. ESI as evidence allows you to do more with less too. Education-wise, I would suggest that you pay attention to webinars, otherwise that you can get up to speed on. You're welcome to follow and leverage any of the content that we put out, which there's a lot that's out there. In terms of finding someone to help you, it depends on where you're located. There are service providers everywhere in the country who can help you really effectively. And these service providers know the ins and outs, and they will help you learn. Part of what they do is help you learn. If you call someone up and say, I really want to find out X, right? Then they're going to say, well, what do you know so far? They're going to help walk you through that process. Anyone's welcome to reach out to me. I'm happy to help them find service providers, folks to help, if that's easier, but really just getting in and starting to do it, but starting to think really clearly about what is the type of ESI that could be there to tell a story. I mean, we've had crazy situations where, someone's arm got cut off in a boating accident and they wanted to determine the timing of it, but the Apple Watch was on the wrist at the bottom of the lake. And the question was whether or not the information from the Apple Watch had been transmitted to the person's phone, which was still on the boat during the accident. And so that syncing capability, right? There's so much you can do with it. You got to start really paying attention. You've got to be engaged. You're not going to get it all perfect to begin with. In fact, I don't think any of us get it perfect at any point in time. But you just got to get in the game, start learning, start paying attention, start asking questions, and find a service provider who will help you. They will educate you. That's how they build client relationships, is by helping you be successful.
That's really solid advice. I want to take a hard pivot because I want to make sure we get in a question or two about your other job, your part-time job, which is teaching. And you teach at the University of Colorado Law School, as you said earlier. So kind of just generally, what has your experience been like teaching the next generation of lawyers? And does anything stick out to you as you're teaching this subject matter? What's different now than when you went to law school? What's better or worse, or kind of just general takeaways from your experience teaching?
When I went to law school, there was no ESI, right? We got DOS-based email when I was in law school, but it very quickly became the thing. I mean, when I came out of law school right away, I was handling a large matter about the construction of an anaerobic wastewater treatment system. And there were all this email, and I showed up to the client and they had printed out all of the email and put it in bankers boxes for me. That's what we were doing then. We didn't even have concordance or summation, which were the early databases to create information. I'll say this, I love teaching. My students are fantastic. They are super interested. Some of them, their second year and mostly third years. A couple of them are in different programs where they're already in the industry, but they're trying to get more of a legal bent. And so they're super interested. And I will say this, anyone who believes that young people, because they grew up using iPhones or technology, that they are thinking about ESI as evidence and understand eDiscovery, they're wrong. I have not found a young person yet who really understands that. Plus, they need to understand what that duty to preserve means, and that when you have that duty to preserve, you suddenly have to issue what we call a legal hold, where you inform your client, here's the information you need to keep, and here's why, and here's what our obligations are. There are processes in electronic discovery that are not generally taught, and there are only a limited number of law schools in the country who do teach electronic discovery. So that's why I try to make myself available to do it. I have a lot of jobs and I like to see my kids from time to time. I can't teach every year, but it's really crucial. And there are some programs, like I mentioned, Bill Hamilton at the University of Florida. He does an amazing job there. And I'll just throw this out for the listeners. Every year, I'm part of a planning committee that works with Bill Hamilton at Florida to put on the University of Florida Electronic Discovery Conference. It is a very practical and free conference to attend virtually. If you sign up for our information at minerva26.com, I think /blog, you can sign up there and you'll get information about the conference. But that, or you can just Google University of Florida eDiscovery Conference and be able to register. It's free. We provide 2 full days of very practical content directed exclusively to eDiscovery, and now some of what the role of AI is in eDiscovery. So that's something I will send my students to. But it's changing so quickly, as I mentioned, all these things. These law students now have to contend to that. And I will say that a lot of times more senior lawyers think that these new students know how to deal with eDiscovery because they've been dealing with technology. And I think that in my experience with students, that is a mistake. they get it a little bit more, right? But they're still not thinking about ESI as evidence in the same way that a lot of lawyers are.
I hope more schools start offering this as a course. I think there's a long list of topics that I hope law schools kind of pivot to and offer for students, but this is definitely one of them. Kelly, thank you so much for being with us. What is the best way for folks to find you and learn more about your work?
Sure. So if you're interested in finding out about the software, you can go to minerva26.com and see about that platform in terms of how it may be able to benefit you in your practice. At my law firm is ESI Attorney, so that's esiattorneys.com. You're welcome to reach me via email. I'll just give my Minerva email, which is kelly.twigger@minerva26.com. Folks, welcome to reach out to me if I can help your navigation through the eDiscovery world just a little bit. I'd be more than happy to.
Thanks, Kelly.
Thanks so much for having me, Lauren. Appreciate being here.
Thanks for listening, and join us again for another Rule of Law podcast from All Rise.